prevail in the matter of Build-A-Bear Workshop UK Holdings Limited and Commissioners for Her Majesty's Revenue and Customs.
Mr. Sykes.
Good morning, my Lord. It is. So my name is Mr. Sykes. I represent Build-A-Bear. Mr. Thomas and Mr. Reynolds represent HMRC in this matter. And I would hope that you have the various notes. I think we've had two from each side, bundles in electronic form as well, hopefully. There are issues of permission. I'm happy to deal with those at the time, or we can deal with those up front.
I think it's going to be easiest if they're swept up in the broader argument.
Yes. Thank you, my Lord. So the structure of my submissions are essentially as follows. There is a conflict or a tension between Note 3, which your Lord and Ladyships will have read, and the language of the DOLS subheading, which specifically refers to parts and accessories, and wouldn't be necessary if Note 3 was doing everything. So there is a tension or a conflict, and I propose to explain that. Also, how that tension is resolved is properly to be viewed as resolved, and then the application to the facts. So what HMRC contend is that the parts and accessories language in the DOLS subheading imports the Note 3 test. And they succeeded on that in the First-tier Tribunal, but not in the Upper Tribunal. Now, the background against which this issue falls is that the scope of Note 3 has already been decided. And the way Note 3 works, and that's been upheld by the Upper Tribunal, is that it's only capable of being satisfied by a single heading. So Note 3 is only satisfied by the items of a single heading, and if that isn't met, then Note 3, if there are two headings that Note 3 applies to, then Note 3 is disapplied. And so that is the background, and the appellant was refused permission to appeal on that point.
There are two headings which are equally in play, then Note 3 is disapplied.
It's disapplied, yes, that's right. The reason for that is Note 3 import, because of the principally language, can only be satisfied by one heading or subheading. Now, conceptually, Note 3 and the parts and accessories language are not doing the same thing. There's no suggestion that parts and accessories means anything other than parts and accessories in the ordinary sense, if not the Note 3 meaning. So it's either you import Note 3 into parts and accessories, or parts and accessories has its ordinary meaning. Those are the two rival constructions. And it's clear that parts and accessories does something beyond what Note 3 does. So parts are accessories which apply equally to human dolls and animal toys. Hearts are the little plastic beating bits of plastic that go into the stuffed toy. Now, what the Upper Tribunal said at 159, which is on page 258 of the core bundle, it is worth noting. And I'll give you, Lord and Ladyships, a moment to read paragraphs 159 to 161. So in other words, because Note 3 does not apply, nevertheless, the hearts fall within the doll subheading because of the wording that is there. Now that is a very strong indication, well it's clear from that the parts and accessories wording is not doing the same thing as Note 3, because Note 3 doesn't apply in that scenario.
When you say not doing the same thing, well, I mean that it's referring to parts and accessories.
Well, it's referring to parts and accessories, but it's not referring to parts and accessories that are solely, principally for use with articles of one subheading, because by definition it's within two subheadings, and yet that language is allowed to function. And it functions because these are parts and accessories of human dolls, even if they also happen to be parts and accessories of non-human dolls. And indeed, HMRC accept this point because if your Lord and Ladyships can imagine, there will be a number of accessories that fit human toys and also non-human toys equally. So, for example, a set of trousers without any slit at the seams for a tail to come out, just a normal set of trousers, will fit a human doll, but they will also fit a doll which is human on the bottom half, but maybe has some super feature the top half of his body, funny ears or horns or whatever. And HMRC accept that that's the case, and that in such an instance, the words of the dolls subheading, parts and accessories, causes the classification to be within the dolls subheading. And they say that in the skeleton argument that was before the First-tier Tribunal, which is in the supplementary bundle at page 228. I invite the court to look at that. Page 228, and it's 72 sub 2. Supplementary bundle.
And you say HMRC accept that. This is a first-tier tribunal skeleton. They accepted it at that stage. Do you understand them still to accept that?
Yes, my lord, because those accessories, the trousers without slits, have been agreed. That's done and dusted, and they are within the doll subheading.
Can I just finish off that thought?
Yes.
Because this is very close to hearts. I
Yes.
thought there was an issue about hearts and whether they were in this heading at all, or whether they actually fall somewhere else.
Yes, my lord, my lady. So what happened is the First-tier Tribunal decided that because Note 3 didn't apply, hearts came, because it applied equally to two headings, hearts came out of the chapter altogether, which was a paradoxical result because hearts apply to two sets of headings, so all the more should they be in that chapter. But instead, the First-tier Tribunal decided that because it applied to two, Note 3 didn't apply, or because two headings were in point, Note 3 didn't apply, and therefore they were taken out of the chapter. Now, the Upper Tribunal took a different view on Bilderberg's appeal and accepted that in such a case, the words should prevail, even though Note 3 didn't apply once you got to that subheading level. Nevertheless, the fact that the wording was parts and accessories meant that the items fell within the dolls subheading. So, although Note 3 didn't apply, the wording, parts and accessories, applied. So that was the difference between the First-tier Tribunal and the Upper Tribunal. And the Upper Tribunal also accepted that word parts and accessories had a different meaning to the Note 3 meaning. The First-tier Tribunal didn't, which is why it was led into that conclusion that parts are taken out of the chapter altogether.
But we'll come to it, but I just had in mind that HMRC was still maintaining that hearts should be classified elsewhere altogether.
But they haven't appealed that.
No, I know they haven't appealed it. I don't think that's a point of appeal, but just so far as the correct analysis goes, we may want to just make sure, I may want to make sure that I've understood where that is set to lie.
Well, maybe I'll come to that.
Yeah, you obviously will, but what I've got in mind, which I think is the same point, is HMRC say somewhere that you only get into the top heading where Note 3 applies.
Well, maybe I can deal with that top heading point now, actually, because given we're dealing with these points. So, Note 3, the Upper Tribunal accepted the proposition that Note 3 applies, can only be satisfied if it would, were it to apply, it would apply to a single heading. However, the Upper Tribunal said that means the heading as a whole. It doesn't mean taking a particular part of that heading. So if we look at if we look at the combined nomenclature, well, in fact, I'll take you to the relevant part of the Upper Tribunal decision, so you have that, and then we can look at the combined nomenclature. It's the Upper Tribunal decision, paragraph 108, which is at page 249 of the core bundle.
Sorry, paragraph 108.
108, my lady.
Thank you.
And it's halfway down paragraph 108. So they say that you look at the heading as a whole, and it's dolls and other toys, and my submission, that's plainly correct, because that explains how hearts get into the chapter. It not only it explains how these accessories get into the chapter, but it also explains how hearts get into the chapter, because if you had to look at individual parts of the heading, hearts wouldn't get in at all. And that would be a very odd result, given these are accessories for toys. And that point hasn't, well, my learned friend will tell me if that's been appealed. I'm not sure that it has. Certainly, hearts hadn't been appealed. The proper characterisation of hearts hasn't been appealed. And indeed, in my submission, the reason why the language in the combined nomenclature for the 9503 heading, the nil-dash heading, is dolls, and at the lower level, it's much more precise, dolls representing only human beings, parts and accessories, is because it's not really caring at the nil-dash level about which item, which individual piece of the definition or the heading is relevant. It's looking at the globality, that's what's relevant. At the lower levels, it becomes relevant, and that's why the language is different and more precise, narrower. So the parts and accessories language on the Upper Tribunal's reading, even on HMRC's acceptance in the First-tier Tribunal, is doing something different to Note 3, and indeed applies when Note 3 doesn't apply. And we say, well, you just read the words for what they are. You can't import a test. Still less so when the words are relevant according to you, when Note 3 doesn't apply. And indeed, it's instructive to note that the combined nomenclature is perfectly capable of qualifying the term parts and accessories with the sort of language that you find in Note 3 when it wants to, and it hasn't done that here. So the example I have in mind is a different section that's not relevant here, but that illustrates the drafting that could have been included but wasn't, and that's at tab 4 of the authorities bundle on page 36. That's the first authorities bundle. And it is the Note 3 on page 36. It's not a chapter that applies on these facts, but this is what could have been included if HMRC were correct in their position. References in chapters 86 to 88 to parts or accessories do not apply to parts or accessories which are not suitable for use solely or principally with the articles of those chapters.
Oh, I'm completely lost where we are. My
I'm
fault.
sorry.
Where are
sorry.
we?
We're in the first authorities bundle, tab 4. And it's Note 3.
I see that, and it's a shame we don't have something like that for what we're looking at. But what I'm slightly lost about what you say it reveals about our Note 3.
Oh, it doesn't reveal anything about our Note 3.
Okay.
What it does reveal is that parts or accessories in the DOL subheading means that. It means parts or accessories. It doesn't import a Note 3 test. If a Note 3 test had meant to be imported, then Chapter 95 could have included this language in order to say, for parts and accessories in the DOL subheading or elsewhere in the chapter, read parts and accessories that are solely or principally for use with the item, which is what Note 3 says. But it hasn't done that. It's just left the wording, it's just left the ordinary words, parts and accessories, in the DOL subheading.
And then this Note 3 would answer your heart's question. Or in the next sentence, a part or accessory which answers to a description in 2 or more of the headings is to be classified under that heading. Oh, well, no, maybe it doesn't.
No, it doesn't.
No,
It goes
it
right
doesn't.
back to where.
Yes. So,
No, I take that back.
the point is, there's nothing to say, and everything to say the opposite. There's nothing to support the proposition that parts and accessories in the DOL subheading means anything other than parts and accessories. Nothing to support the Note 3 test being read into that. And indeed, on the Upper Tribunal's case, on HMRC's case, that language is relevant, and it's relevant when Note 3 doesn't apply. And we say quite simply, parts and accessories means parts and accessories. And I'm going to go on to describe.
So omitting the principal use.
Yes.
Yeah.
It can't be a theoretical use, but there isn't this sort of looking at the minutiae of details and specifications that Note 3 comports. And there's a reason for that. Makes perfectly logical sense that the combined nomenclature adopts that approach. So that's the starting point. Now the decisions, if I can just flag the relevant parts of the decisions. So we have the first-tier tribunal. This is in the core bundle, and the key paragraph is 177. I'm sorry, yes, 177, which is on page 199. And then at paragraph 185, the tribunal specifically says that note 3 the impact of note 3 is that it's irrelevant that the accessory can fit dolls because it's got these extra features, and it's irrelevant that they don't detract because of note 3. And then 187 is also an important paragraph. Because the tribunal specifically rejects the proposition that it is relevant whether the extra features hinder use with a doll. The tribunal says, well, that's irrelevant. They've got these extra features. It's enough. I don't need to consider whether they hinder or help play with a doll. They can't be explained by use with dolls, and therefore, under note 3, they are solely or principally suitable for use with animal toys. And then at paragraph 188, one can see that that is the conclusion, that accessory in the doll subheading means imports the note 3 test.
So just give me a moment to read it.
Yes, I'm sorry. Now, it's relevant to point out that in paragraph 177, which we looked at before, on page 199, the judge did have a sort of backup argument, which is sort of half pursued, which is, well, even if you don't read note 3, the accessory of concept, nevertheless, on its own language, involves a solely or principally test in the same way that note 3 does. The judge didn't really pursue that alternative line because when she was looking at Invermed, paragraph 185, she said, well, note 3 requires that I ignore the issue of whether the accessory can be used with human dolls, given it's got these extra features. It's note 3 that was requiring her, on her view, to do that. She didn't consider whether that was required under the ordinary concept of part or accessory. So that sort of, and indeed the conclusion at 187 is solely, 188 rather, is solely predicated on note 3. So that point throwaway comment in 177 is not really pursued. And if it is pursued, it's pursued wrongly in my submission. But it doesn't play any part in the further reasoning. Now, the Upper Tribunal recognised that the First-tier Tribunal was wrong to read note 3 into the doll's heading. And that's page 249 of the core bundle, tab 13, and it's paragraph 112. And then at 119, the Upper Tribunal explains that in a bit more detail, acknowledging that an accessory on its ordinary meaning can have more than one principal use or can be used with more than one item. Then at 124,
Can you ask him to read 111 as well?
I'm sorry,
Can you ask him to read 111 as well?
paragraph 124, the Upper Tribunal considered that even if we accept the possibility that the clothing and wigs might also fall within heading 95030029 as parts and accessories of dolls, on the basis that Mr. Sykes contends, i.e. that a main intended use of the clothing and wigs is an accessory to dolls, the direction in note 3 is clear, and so classification in accordance with the note 3 must take precedence over the classification of the dolls subheading. So they acknowledged that note 3 wasn't to be read into parts and accessories, but they said note 3 overrides that. Now, in fairness to the Upper Tribunal, one of the points that the appellant is making today, that I'm making today, is that GIR 6 resolves the tension between note 3 and the wording of the subheading. I'll come on to that. But in essence, GIR 6 says if there is conflict between a chapter note and the words of a subheading, then the subheading language prevails. The note is disapplied. Now, the Upper Tribunal didn't have the benefit of that submission, and so there was no easy way to resolve the conflict between note 3 and the parts and accessories language, but GIR 6 provides that because it says where there is conflict, GIR 6, the chapter note will not apply. I'll come on to that.
Just to follow again,
Yes.
that it might be said there isn't a conflict here. On the Upper Tribunal's conclusions, what's happened is they say you've got the words, parts and accessories in the subheading, and it stands on its own 2 feet, it means what it means. And then you separately got note 3, which has two specific component parts. One is that parts and accessories are, you look to what their principal use is, and that there's then a mandate to classify them according to principal use. So you've got those two things happening independently. Not that they're in conflict, it's a question of sequencing, which one predominates.
Yes, but there can be a conflict, and I'll make that good maybe in a moment. There clearly are circumstances where one has to disapply note 3 because the wording of the subheading, or the competition between subheadings, involves a subheading which refers to parts and accessories. And therefore there would be conflict, because if one applied note 3...
You say it's broader.
Yes.
It's for exactly this
Yes.
case. You say you get into parts and accessories if they're just given an untrammeled reading. But
So-
they don't if you give them a note 3 reading.
Yes, and note 3 would bring in the accessories into other headings, other competing headings.
Yep.
So, and my submission is that the Upper Tribunal, without the benefit of GIR6, erred in this respect. And my submission is that one does not take into account note 3 at the subheading level, where one of the competing subheadings specifically refers to parts and accessories. One doesn't need note 3, and indeed it's inappropriate to read note 3 in. I'll just flag the point, I'll make it again later, that GIR6 is just about subheadings. It's not about headings. So chapter notes on the face of it are about headings. GIR6 says, when it comes to subheadings, tread more carefully. Don't necessarily apply chapter notes if the context otherwise requires. That's about subheadings. I make that point because some of the cases relied on by HMRC are about headings, to say, why didn't the court bring in GIR6? Well, those cases are about headings, not subheadings. So GIR6 wasn't relevant.
So just so I understand that, where you have an item such as has been found to be the case here, which is principally for use with bears, but also of use with dolls, you say, well, you're obviously in the dolls subheading because it's an accessory of the doll. And you don't come into the toys subheading at all?
No, because note 3 is disapplied. Note 3 isn't applied because it would enter into conflict with the wording of the relevant subheadings. I'll
Because it diminishes the express word.
Yes, indeed, my lady. So what are parts and accessories? What's the ordinary concept of parts and accessories? Well, the Supreme Court has considered this point in a case called Amina, and that is in the third authorities bundle, and the relevant section, tab 39, and the relevant paragraph is page 690.
Sorry, Amina.
Yes, my lady. So, page third authorities bundle, tab 39.
What is it?
Page 690.
I'm really having struggle to hear you.
I'm
could I-
sorry.
could I
I'll
possibly
try and speak. I'll
Thank
try and
you very
speak. More loudly.
Thank you.
And it's paragraph 31. Paragraph 31. If I could invite the court to read paragraph 31.
Is it a typo at G where it talks about customs with an
Yes,
ES? Is that
that's
HMRC? Is that what it means there?
Yes, I imagine so.
I just wondered.
I don't.
Theories, I'm not aware of a word that has the E in it.
But it means argument for HMRC. I
Yes,
think.
my lady. Presume so. So what's interesting is that Supreme Court considered parts and the Supreme Court approved the view of the Upper Tribunal, and indeed paragraph 44 applied it themselves. What's interesting is that it's an ordinary meaning. Parts and accessories is an ordinary meaning. An accessory does not have to relate to a specific design, just as a bicycle bell may be fitted to a variety of bicycles and will still be regarded as an accessory. In other words, it's a flexible term. It's a broad term. It's a common sense term. In paragraph 44, they applied that to the bra in question. Performs a particular service relative to the main function of the breast form. Now, it's quite true that in construing the combined nomenclature, theoretical uses are ignored. It's not about squeezing in as many different possible uses for an item as you can. It's about looking at practical use. And there are two cases which summarise the position. The first is a decision of the Court of Appeal in Honeywell, which is in the third authorities bundle at tab 41, and page 742 is the relevant section. And this is, I'm sorry, 733. So the Master of the Rolls was in the minority in this decision, and this section is the Master of the Rolls, an extract from the Master of the Rolls speech. However, Lord Justice Sales agreed with these specific paragraphs, 67 to 69. And so if I could invite the court to read those paragraphs, because although the court had some disagreement about the application of the principles to the particular facts, they were agreed as to these principles. And then at page 742, Lord Justice, paragraph 116, Lord Justice Sales agreed with those paragraphs, 67 to 69. And at paragraph 112, the third judge, Lord Justice Davies, at 112, makes the point that principal use can be conceivably multiple, more than one. principal use. It's got to be a main intended use. It doesn't have to be a single one. So that demonstrates that theoretical uses are ignored. One is looking for a main use. Doesn't have to be the only main use. There can be more than one. Now, Huxley is an Upper Tribunal decision, which is also useful in summarising the Court of Justice case law. That's still in the same bundle in the previous tab, tab 40. And the relevant paragraphs are 59 to 61, which are on page 710.
Sorry, which paragraphs?
59 to 61 ones.
59 to 61.
Starting on page 710.
Shall we just read those?
Yes. So I would.
Can I just?
Yes.
Sorry, but say what you're going to say, and then I might ask you a question.
Yes. So I would summarise those two authorities as supporting the proposition or stating the proposition that theoretical uses are ignored. One is looking for the practical use, the use in practice. And it may mean, as the Master of the Rolls said in Honeywell, that the GIRs are needed to resolve the competition. One isn't necessarily just trying to slot things into one particular heading.
Just help me.
Yes.
How does Huxley help with that? That seems to postulate a single main use. I mean, or arguably, if you look at the quotation from the Court of Justice, the product doesn't have to be solely or exclusively intended for that use. It suffices if that is the main use.
Yes.
So there we get an exclusive use or the main use.
Well,
so why
it can be a main use with different. I mean, I would say that use with a doll, which has got a tail, or doll which doesn't have a tail, is the same use. It's just use with two items that happen to be within two different subheadings. So the assumption that's being made by the court there is that most things will have a single use. That doesn't preclude them having that single use being with items that are in different subheadings. If one is playing with trousers, toy trousers, whether it's with a doll or a bear, that's the same use. It just happens to be the use with different items in different headings. So that assumption holds. There is a single use. Lord Justice Davies in Honeywell makes the point, well, it can be potentially a main use. There can be different uses.
Can I just see that again? So that
Yes.
was 112.
112 onward. Page 741.
Well, does that really help? The quotation, again, draws the distinction between exclusive use and main use. And then Lord Justice Davis says, even on this alternative basis, I would query if the respondent could have succeeded here unless it could have established that it was the or possibly a.
Yes.
So I'm not sure that answers the question.
Well, the point is that one is looking. There are no strictures. One is looking for most items, including these clothes, will have a single main use. Now, the main use is playing with toys. It doesn't matter whether it's a human doll or an animal toy. It's still the main use. So the assumption that's made is that most things will have a single use. I think that's a fair assumption, and that's why the court is talking in the way that it does. But clearly, that doesn't mean to say that the things that this is an accessory of need to be within the same heading for that to constitute a main use. I mean, that would be pushing things, I submit. It's toys, whether predominantly human or solely human, can't make a difference.
I mean, at any rate, they're in the same heading, you say, at the top level.
Indeed, my lord. So this is simply to illustrate how flexible, how much this is a question of looking at practical use and applying, as Amina says, the ordinary language. Now, if we contrast this with the Note 3 test...
Before you do that, could I just ask you, in very simple terms, to explain, therefore, your trousers are, the main use of those trousers is to be used with toys, and therefore you're in at the top heading. And where do you go from there? Your main use is in relation to toys. It's an accessory in relation to toys, and then you go down to the heading, which mentions expressly accessories.
Yes.
That's your route.
Yes. You have a thought. Do I apply Note 3 at that subheading level, and you see that parts and accessories are expressly mentioned?
And you don't, because they're expressly mentioned. But that would mean that all accessories, and I'm using that word because I can't think of another one, whether it's trousers or shoes or wigs or I don't know, little plastic mobile phones or whatever, all those bits which are sold with the toys and are used with toys, does that mean that they would always fall then into dolls because of the express wording, and they'd never go anywhere else?
Yes, so indeed there were accessories of that nature that were in dispute in the Upper Tribunal, and the appellant succeeded on that.
Yes, I'm sorry to repeat, but I just... Yes,
it does mean that. If, however, the accessory, because those are accessories both of human-only dolls and of quasi-human toys, and it makes sense that they go with the doll subheading, because that's the appropriate place. They also work with quasi-human dolls, but by their nature, they're toys for human dolls. They're appropriately described as such. Little telephones, bicycles, all the rest of it. That is right. However, if there's an accessory like a kennel, for example, then that goes into the other toys subheading.
Can I just, thinking back to when my children were of the age to be interested in these things, they did know about Build-A-Bear, and at that stage I don't think Build-A-Bear made dolls. If we assume that the clothing didn't change when the dolls were introduced, before the introduction of dolls, you say they were in the toys subheading.
No, my lord, because they have always, these accessories have also been used with other dolls produced by other manufacturers. Indeed, in the supplementary bundle, you'll find photographs precisely of that. You'll find photographs of the accessories with dolls made by other manufacturers, and the evidence before the First-tier Tribunal was that this was an important stream in Build-A-Bear's offerings. So we would always say...
So the point doesn't work on the facts, but you accept that if you have something that isn't dual use, it will come within the toys subheading.
Yes. If it's not aptly described as a part or accessory of a human-only doll, then it doesn't go within that heading. And then the heading would be the toys subheading.
So do you have to work out then the accessory, and if it's a phone or a bike that a human would use, it's in the dolls as an accessory. But if it's something like a kennel that only an animal would use, it defaults to the toys subheading.
Yes, my lady. And indeed, that was, to that extent, mobile phones were classified, for example, with human dolls, the dolls subheading.
But as my lady asked, there must have, I mean, those are nice examples because you can put them in one or other bucket, but what about something like a scarf or something that would be equally useful for an animal toy as it would for a human toy? Would, on your analysis, you go into, it's all the same, the
Yes.
process is the same,
Yes.
and you end up in the dolls subheading,
Yes.
even though your scarves might just as well,
Yes.
or even better, fit a bear,
Yes.
but because they could properly be referred to as an accessory,
Yes.
human toy,
Yes.
human doll, they go in there.
Yes,
even
my
if
lady.
it's a sub-use, even if it's a less likely use.
Well, these are intrinsically human.
A Rupert the Bear waistcoat, let's say.
Yes.
So, you know, you might say mostly that's for bears, but some human doll's going to wear it too.
Yes. And there's nothing to say it's just for bears. It might be. Absolutely, because we're talking about intrinsically human items. I mean, animals don't wear clothes. I don't make that point facetiously, but it's a point that comes up in relation to shoes. It's quite a surprising comment by the Upper Tribunal, which is, humans don't have rounded feet. Well, yeah, but bears don't wear shoes. These are human accessories, and they fit human dolls. So it's entirely logical that they would be classified with human accessories, even if they fit quasi-human toys.
And I think this is the same point, really. Say you have a Paddington accessory. I don't know what, his hat. Say with holes in for his ears. I can't remember whether Paddington hats do have holes in for ears. Perhaps they don't. That's obviously primarily for Paddingtons, which
Yes.
are bears.
Yes.
If you could show that there was some species of doll that could wear the hat.
Well, indeed, hats did come up, and we've conceded that point. The hats did have slits. We're not appealing those because the tribunal found that the use of the slits, say to pull your hair through, was purely theoretical. So that is gone. Those are correctly classified as accessories of other toys. However, and the accessories that are an issue are, it's not even all the clothes. It's the clothes, it's the clothes with the where the slit is on the seam. It's barely visible. It's not the woolen or the woolen type that First-tier Tribunal described. It's those that are discrete, and they work with human dolls. The tribunal accepted that the slit was discrete, did not interfere with use with a human doll, And we say, well, it's a part and accessory. It's a part or accessory in that case, and therefore falls to be classified with human dolls. And indeed, those accessories are sold with human dolls, Build-A-Bears, human dolls, and used with them. So makes perfect sense, my submission. So just to contrast the part or accessory, the ordinary concept, as elucidated by the Supreme Court in Amina, with Note 3. So what the Upper Tribunal said, and First-tier Tribunal said as well, is that Note 3 can only be satisfied by a single heading, although, as the Upper Tribunal said, it's the heading as a whole, it's the heading or subheading as a whole. Also relevant is how the Note 3 test works in practice. It's any little difference that counts. According to the First-tier Tribunal, upheld by the Upper Tribunal, and permission has been refused on that. So if we see the core bundle, the submissions of HMRC, which were accepted in their entirety by the First-tier Tribunal, it's at tab 11, page 191 of the core bundle.
Page number?
Page 191, my lady.
Yep.
And it's paragraphs 162 and 163. These are HMRC submissions.
Should we just read those?
Yes. And then, so it's enough that the features simply can't be explained as being of any use for a human doll, according to HMRC. If we look at the tribunal's decision on this point, it's at paragraph 171 on page 196. And it's points 1 and 2, subparagraph 1 and 2 of paragraph 171. And so we saw, and so this, in conjunction with paragraphs 185, 187, demonstrate that the tribunal's view was, if you've got a feature and it can't be explained by use with a human doll, then Note 3 means that it's with the animal toys, and it does not matter, it is irrelevant, the extent to which that feature detracts from use with the human doll. That was paragraph 185. When the First-tier Tribunal discussed Infomed. It's enough you've got a feature that can only be explained with an animal toy, as for use with an animal toy, but it's irrelevant whether that feature gets in the way or not. So that, this is not to challenge that, it's to simply, that is the law as has been found, it's to simply say what a difference to the ordinary concept of parts and accessories. Because I would say, I submit, if you've got a slip that it doesn't get in the way, children don't care, it doesn't make any difference. It doesn't stop it being a part or accessory.
Well, accessory.
Or accessory, indeed. Thank you, my lord. Now,
Hey, sorry, I'm being stupid.
yeah,
The FTT doesn't does it say otherwise? I mean, it does by reference to note 3, but it isn't saying it isn't an accessory.
no, it doesn't say it isn't an accessory, and the Upper Tribunal says, well, even if we were minded to agree with Mr. Sykes these are accessories, it's not relevant. So it hasn't actually been decided that these are accessories. However, I think now would be a convenient point just to show the facts that have been found, from which your Lord and Ladyships will be able to see that these are accessories. Clearly, Bilderberg needs an answer. If the court agrees that parts and accessories is the relevant concept, needs an answer on that. Now, there are issues being remitted back to the First-tier Tribunal in any event, as you can see from the end of the Upper Tribunal decision. But in my submission, given the facts as found, it's clear that these are accessories. And if I may just take you to those findings, once I've done that, then I will come on to how we GIR 6 and GIR 3A in the alternative operate so that there is no conflict between note 3 and the parts and accessories wording. But before I do that, I think I need to show you why these are parts and accessories so that you have all of the relevant facts. So firstly, the accessories were sold with human dolls. So the paragraphs of the first-tier decision starts with paragraph 5, where the evidence was accepted unless stated otherwise. So paragraph 5, that's on page 156 of tab 11 of the core bundle. So the evidence was accepted unless stated otherwise.
And just on this,
yes,
you say that you're bringing out the point that these items were accessories. I mean, in one sense, everybody agrees they're accessories, don't they? Because otherwise, you wouldn't have note 3. I mean, they wouldn't be within note 3 if they weren't accessories. Your point is that they are naturally to be construed as accessories of dolls as well as stuffed toys.
Yes, and that's the point. That's the point that these findings demonstrate and support.
Yes, I see.
So paragraph 5, then it's paragraph 9 to 10, which explains.
Let's read those.
Yes, 9 and 10. And paragraph 18 this is in relation to other makes. And then paragraph 25 on page 160. paragraph 60 on page 167 is about the seam. And just to flag before you read that the items with the drop stitch technique, that appeal is not being pursued. So we have conceded those because the slit is more visible. It's where the seams, it's where the slit is in the seam that the appeal relates to. And then paragraph 183 on page 202. And I think we've looked at this before. It's really 182, so 183, 184.
So we just read those.
Yes, 185 and 187.
Those ones we have seen before.
Yes. One 184, 185 is the key bit. And then 187 as well. So they can plainly be used, according to the First-tier Tribunal, with any toy or doll of an appropriate size, and the slit is discrete and doesn't interfere. So in my submission, these are accessories of human dolls. Indeed, they're sold to be used with human dolls as well. There's no question here of any of use with human dolls being theoretical in my submission. It's use in practice. And so in my submission, that the facts have already been found. It is clear that these are accessories. If one does do what the tribunal said it wasn't going to do, which is to consider whether the clothing items have lost or retained their character as items which provide a clothing function because of the slit. The answer to that is they haven't. The tribunal answers that question itself. And so these are accessories of human dolls. So those are the facts. As I say, no one has actually answered directly that question, are these accessories? Because First-tier Tribunal thought that Note 3 was to be read into parts and accessories, and the Upper Tribunal says, well, even if we were prepared to accept that, we don't have to deal with it because Note 3 takes priority. So I now want to just explain the point about GIR 6 and GIR 3A and how this contest between Note 3 and the plain wording of parts and accessories is resolved. Now, GIR 6 is in the authorities bundle at tab 1 on page 6. Well, if we start off with GIR 1 before we go on to GIR 6, which is on page 5 of the authorities bundle. GIR 1, and this is a point made by the Upper Tribunal, provides that for legal purposes classification shall be determined according to the terms of the headings and any relative section or chapter notes, and provided such headings or notes do not otherwise required according to the following provisions. That's about headings. So in other words, the 9503 heading.
Can I just pause there?
Yes.
I stopped at this point and saw the reference to chapter notes being read alongside headings, and that suggested to me that you did put note or use note 3 in construing the heading.
You do, my lady.
Okay.
When it comes to subheadings,
Yeah.
it's different.
I thought your submission, I was just looking back at my own notes, I thought your submission was that note 3 wasn't relevant when you were looking at the heading. It was just a sort of bucket of things.
It's relevant when you're looking at headings, because the headings need to be construed with the chapter notes. But when you're looking at subheadings, GIR 6 is phrased differently.
Just pause there then. Sorry,
yes.
I have misunderstood your submission.
Right.
I thought your submission, just highlighted it to myself, that you took us to paragraph 108 of the Upper Tribunal and said you look at the heading as a whole, and we were talking about hearts, and I had recorded your submission to being, we say that note 3 doesn't apply at heading level.
No, my submission is it does apply at the heading level, but as the Upper Tribunal held, you apply it to the whole of the heading. So you apply it to dolls and other toys and all of the other things, and you say, well, if the use of this accessory is with items of this heading, then note 3 is satisfied, the item goes into that heading. So the Upper Tribunal, so you're not looking, so I think the point there that was subject to discussion was, do you look at individual items of 9503? In other words, do you just look at dolls or other toys, which is what HMRC say? The Upper Tribunal said, no, you look at the whole of that heading, and we say they're right, because if you didn't look at the whole of that heading, hearts would never get into the chapter, which can't be right.
So the solely or principle test is more loosely applied, and we can find different ways of formulating it. But you say as long as these accessories are solely or principally used for dolls, toys, models, puzzles, that sort of thing.
Yes.
This is where you're headed.
Yes, my lady, that's right, and that's what the Upper Tribunal held. But when it comes to the subheading level, then GIR 6 changes the emphasis. And it says, for legal purposes, and that's on page 6, for legal purposes, the classification of goods in the subheadings of a heading shall be determined according to the terms of those subheadings and any related subheading notes, and mutatis mutandis to the above rules, on the understanding that only subheadings at the same level are comparable. For the purpose of this rule, the relative section and chapter notes also apply unless the context otherwise requires. So chapter notes apply unless the context otherwise requires. And that's different to the position at heading level.
It is different from the position at heading level, is it? Sorry. If we go back to GIR 1, classification should be determined according to the terms of the headings and any relevant chapter notes, and provided such headings or notes do not otherwise require.
Well, then according to the following provisions. So that provided such headings or notes do not
Yes.
qualify for,
Okay.
yes. And in fact, there's a harmonised system explanatory note on GIR 6, which is a tab. It's in the third authorities bundle at tab 46. Tab 46, page 845. And so it explains, unless the so this is in B, 2B, unless the context otherwise requires, in other words, except where section or chapter notes are incompatible with subheading text or subheading notes. And then it gives the example of a situation involving platinum where the chapter note is incompatible with the subheading note. The situation we have here is a different one. It's where the chapter note is incompatible with the subheading text. It's a different situation, but one which is described here without giving an example.
So the thesis is that note 3 is incompatible with the DOL's subheadings reference to parts and accessories.
Yes, and the basic, yes, and we can see, we can take two examples of that, different examples of that. So if we look at the chapter 95 itself, which is in tab 5 of the first authorities bundle. And it's page 59. And it's the ice skates and roller skates, including skating boots with skates attached. It's 950670. Now, if you didn't have parts and accessories, well, I'll make 2 points. Firstly, you clearly don't read parts and accessories into ice skates. So in other words, 95067010, or into roller skates, 95067030. You don't read parts and accessories into that, because parts and accessories has been separately provided for. So clearly you don't, and secondly, there's a reason for that. This is deliberate, because if you didn't have the parts and accessories subheading, the 2- heading, then parts and accessories of ice skates would attract nil duty. You see the penultimate column says free, that means nil duty. So if it just said ice skates and roller skates, then parts and accessories of ice skates would attract nil duty because they would be classified with ice skates. Parts and accessories of roller skates would attract 2.7% duty. But that's not what's been done. Parts and accessories has been inserted so that the parts and accessories that have got to that section are charged 2.7%. So this is a deliberate use of language to achieve a certain result. It's not a coincidence. And then if we look at page 57.
Pause. So this is saying that parts and accessories, whether they go with ice skates, roller skates, either or both, you're going to be charged at duty.
Yes.
So our case is the other way around, isn't it? It's saying parts and accessories in broad terms with dolls and bears.
Yes.
The reason you want dolls is because that would get you into nil.
Yes. And there's no principle that all parts and accessories have to be charged when the principal item isn't. There's no principle to that effect. We say the logic of parts and accessories of human dolls being, even if they fit non-human toys, being, well, there's going to be lots of accessories that fit human dolls and animal toys. There's going to be lots of accessories that fit both. And if they're human toys, well, they're not going to be penalised simply because there's some non-human toys that they can also fit. That's basically the reason. The distinction between human and animal is so slight, just one non-human feature is enough to take the actual figurine itself out of human into animal.
Well, I understand your case, but I suppose the counter-argument would be that's fine and good so long as the accessory in question is mostly used with human dolls. You can see why it should benefit from the same nil rate. But it's a slightly peculiar outcome where you know that the accessory in question is mostly or predominantly used with bears, yet you say it defaults into human.
Well, you don't. We don't know that.
We do. We have a finding to that.
No, we have a finding based on a particular legal test that it's solely or principally suitable for use.
Yeah, solely or principal, as I recall it, being a term that's to be given its ordinary meaning. It's not got a special legal meaning. So there's a finding of fact or mixed fact and law, if you want to be cautious about it, is that they're mostly used for stuffed toys.
No, Molly. The finding is it's suitable for use solely or principally for animal toys based on the fact that it's got a feature that can't be explained otherwise. There was no finding about use.
Right, okay.
No.
You've got
and
we
we
can't
say,
go behind that finding in the tribunal.
But I'm not seeking to disturb the finding that there is a slit. In fact, the actual findings of fact are it doesn't get in the way of use with a human doll. It's sold with human dolls. It's used with human dolls. And it doesn't detract. So it's not actually about looking at statistically whether it's used more with this, or it's looking at the inherent characteristics of the object. It can be seen that it works perfectly well with human-only dolls. It's sold with those.
Well, we've been through it. I mean, I've got the point.
Yes.
We've all read the findings. So
Yes,
I know where we are. But
yes.
That is, to my eye anyway, a slight conundrum on your case you advance.
It's consistent with the fact that even a trousers without a slit would fit non-human toys. So if there's and clearly that would be classified in the dolls subcategory. The fact that there's a seam that is discrete can't get in the way of use with a human doll. My submission puts that in exactly the same position.
I mean, whether or not it's so in this case, and you say there's no finding on it, it is a bit counterintuitive that an item that is produced with bears in mind, and we suppose, ignore this case, suppose a case where they are sold overwhelmingly for use with bears, nevertheless bears no duty because they can, in more than non-theoretical circumstances, be used with dolls.
Well, these were sold with sold 4 human dolls and actually Build-A-Bear produce its own human dolls itself. And to answer the question specifically, it's about looking at the objective characteristics of the item rather than looking at sales data. And if one looks at the item, and also taking a step back, bears don't wear trousers normally. Animals don't normally wear trousers. We are talking about inherently human accessories. So one could flip that observation the other way and say, well, it'd be odd if they weren't classified with human dolls, because these are human accessories.
I mean, just pursuing it a moment longer, you didn't always produce dolls, but as you explained, it turns out that the items that you produced for bears could in fact be, and were in fact sometimes, used with human dolls. So you could have a case where you produce an item entirely for bears, but nevertheless escape duty because somebody else happens to produce something that can make use of this garment.
In a real practical sense. Yes, my lord. And it could work the other way. I mean, it could work to the taxpayer's disadvantage. And it's a function of the fact that it doesn't really matter why you're producing it. You're looking at the object itself. And yes, you can bring in actual use to support the significance of particular features. But really one is confined to the object itself. And that's because at the end of the day, there is a man or woman at customs who's got to apply these tests in a real sense. He sees some trousers with a slit that doesn't bother anyone, it's barely visible, and he sees a customs code that says parts and accessories of human dolls. He's not going to go through the sort of mental somersaults that HMRC are going to be inviting you to jump through to get to the plain conclusion. He's going to say, these are parts and accessories of human dolls.
You might say these are obviously designed for use with bears.
Well,
so I'll stick them with
it would be a strange, wouldn't be an ordinary bear that wears trousers. These are sort of quite particular bears. But he's going to say, well, okay, maybe they can be used with figurines that have got horns, these trousers, for example. But looking at the combined nomenclature, it says parts and accessories. That's it. I can classify them and move on to the next crate.
And so for you, your argument is that all accessories will fall into the doll category unless they're a kennel, a dog bowl, a dog bed. These are just examples, things which are specifically can be seen, obviously, to be designed for an animal, a cage, but something, moving away from clothes, but something which is a bed for a toy or a chair for a toy would fall into the doll category, despite the fact one might say, for example, beds and chairs fall neatly into three bears category, small, large, and medium-sized bears. But you would say, on the face of it, they're quite clearly things that humanoid toys use.
Yes, yes.
And that's just your simple line.
Yes, but if they are parts and accessories of human dolls, and that's how they fall to be classified. And indeed, in the first-tier decision, there were a number of items, such items, and the taxpayer succeeded on that. And we say there's nothing really surprising on that, given anything really that can be used with a human doll can also be used with a quasi-human doll. So human is the place. Now, the point that my Lady Justice Whipple made is we were just looking at was skates, and you can see there skates, which was on page 59, and we can see that parts and accessories there. It's parts and accessories in the ordinary sense. That includes parts and accessories, whether they're solely or principally for ice skates or solely or principally suitable for use for roller skates. It doesn't matter, they're lumped together as parts and accessories, because that's what they are. They're parts and accessories that have got to this level. Similarly, if we go to page 57, again, we have, which is the level below the doles subheading. It says doles and parts and accessories. Well, again, you don't apply, where you've got parts and accessories separately provided for, you don't apply note 3. It's a matter of common sense, because otherwise things would be going into doles, or there would be a conflict. Clearly, you don't apply note 3 at this level because parts and accessories are specifically provided for. And that's exactly what's happening here. That's the essence of the case, because we have got 2 competing headings, one that describes parts and accessories of dolls representing only human beings, so parts and accessories are specifically mentioned, and then the other is toys representing animals or non-human creatures. Now, the draftsperson has gone out of their way to mention parts and accessories thereof. They didn't need to give them note 3. They could have not put it in, but they have put it in. And the reason they've put it in is because by putting it in, that makes it clear that if you have something which is a part and accessory of a human doll, that's where it goes.
So when I get to, let's just say, for the sake of argument, I'm a customs officer and I've looked at dolls and I've taken your arguments on board, but I just run my eye down and I get to toys representing animals or non-human creatures, because I've got these items I don't quite know what to do with them. And I say to myself correctly, I think, on your argument, note 3 must apply here because it's not obviously knocked out of this toys subheading.
I'm sorry, so the accessories are clothing items.
So I've got some clothing items in the back. Right. Yeah, I'm trying to work out what to do.
Yeah.
So I've got toys representing animals, so non-human creature toys. And I say to myself, I wonder if they might go in here. And I would correctly say to myself, wouldn't I, note 3 must apply at this level, because there's nothing here to tell me note 3 doesn't apply.
Which level is that?
I'm in toys representing animals, the single one dash subheading.
Yes.
Okay. Note 3 does apply, doesn't it?
No, because GIR 6, because the competition is between dolls representing only human beings and parts and accessories thereof, and so the competition is between the same one dash headings.
Okay.
And so GIR 6 says, well, if you apply note 3 to toys representing animals and non-human creatures, you've got a conflict with the competing one dash level, which is dolls representing only human beings and parts and accessories thereof.
Yeah. So that's the point, isn't it? Is that your analysis using GIR 6 says not only does note 3 not come into the dolls one dash subheading, but it necessarily doesn't come into the toys one dash subheading either. Because if you put it into one and not the t'other, you'd land up in a pickle.
Yes, my lady. Yes.
So in fact, it's a more dramatic, it's a more significant submission than I think I had first appreciated. That actually note 3 falls out altogether at the one dash.
At this level. Yes. Yes.
But it doesn't with the kennel.
Unless you've got a kennel, exactly.
Because the kennel isn't a part or accessory of a human doll.
No, but to that extent, note 3 must apply to the toys subheading. I mean,
Yes,
in
my
order to
lord.
get the kennel in.
Yes, my
In
lord.
order to get
Yes.
the kennel in.
Yes, my lord. Yes.
So how does that work? What does the custom officer say to himself? I've got a kennel here. It can't be an accessory of a human doll because it's a kennel. It must be an accessory of a toy representing animals. But it's an accessory, so the only way I can get it in there is if I apply note 3. And
Yes,
that's
my lady.
because in my mind I've already disregarded a competing one dash subheading, the human dolls. I know that's not in the frame.
Yes, my
So I
lady.
don't have to worry about a comparison at that point.
Yes, my lady. Now, GIR 3 provides another means, if one were in that situation that my lady described, where one is applying Note 3 to the toys representing animals or non-human creatures, but one also has got the heading parts and accessories thereof, then there is a conflict. Let's say that GIR 6 does not resolve that conflict. GIR 3 resolves that conflict. And that would be another way of reaching exactly the same result. GIR 3 is in the, again, it's in the authorities bundle, page 5, tab 1. And it's GIR 3A that is the relevant provision of GIR 3 on page 5. And it's the first sentence of GIR 3A. And the Dole's subheading is the more specific because it specifically brings in parts and accessories. And for that reason is more specific, and therefore that is where classification would fall. Now that was accepted by the Upper Tribunal in principle, in a slightly different context, but applies equally. Page 258 of the core bundle, it was at paragraph 162 of the Upper Tribunal decision. This was dealing with hearts. But if one reads paragraph 162, the Upper Tribunal accepted that because the Dole subheading mentions parts and accessories, it is more specific and therefore would win under GIR 3A.
This is in circumstances where Note 3 won't apply because the items are not principally for use with bears.
Yes, that's right. But they say even if we're wrong on that point, and Note 3 does apply, and there is a competition, then that competition is won by the Dole subheading by virtue of GIR 3A. So they are postulating a competition on the basis that Note 3 is applicable. Now, and my submission that is
applicable but not overriding.
Not overriding.
I mean, I'll confuse everybody again. An alternative view is, well, Note 3 just tells you the answer.
Yes.
You don't get to a competition. GIR 3A doesn't bite because Note 3 has already told you
Yes.
that you just apply.
Yes. And that was the view of the Upper Tribunal.
Yes.
But they said even if we were, well, in relation to hearts, they accepted that Note 3 sorry, your Lordship is quite right in that was their view in relation to accessories, but they were postulating here a competition where Note 3 did still apply. And
Note 3 was capable of applying but didn't actually apply because there was no primary purpose.
But they said if we're wrong on that,
Oh, yes. Yes.
So the only point I wanted to, I didn't want to confuse
Yes.
anyone, is simply to say they accepted that if there is a competition between Note 3 and the parts and accessories language in the DOL subheading, GIR 3A means that the DOL subheading wins because it's got the language, parts and accessories. It's more specific. And I say that if your Lord and Lordships don't accept it's GIR 6 which resolves the conflict, then it's GIR 3A. And in applying GIR 3A, it's a linguistic approach that is required. And the authority for that is Hasbro, which is at tab 43 of the third authorities bundle.
It must be 42.
Sorry,
I think it must be tab 42.
Apologies. Tab 42, thank you, my lord. And of course, my Lord Justice Newey will be familiar with this case. It's paragraph 41 to 43, which I would just invite the court to read on page 766. It is a primarily linguistic analysis, and in working out what is more specific, what is more general, one is looking to see which concept includes a greater number of sub-concepts within it. The other case on GIR 3A is Xerox, which is in the second authorities bundle at tab 37. And this was an Upper Tribunal, High Court, Upper Tribunal decision. Tab 37, page 643. And it's paragraph 50, and the judge simply says you're looking at the relevant bit of the heading. So in this case, it's parts and accessories rather than the whole of the DOL subheading. You're comparing that to the relevant bit of the animal toys subheading. So I'll give your Lord and Lordships a moment to read paragraph 50. And so that explains why the reference to parts and accessories makes the doll subheading more specific than the animal toy subheading. One is looking at the parts and accessories wording, not the rest, and comparing that to the animal toy subheading, which is broader and doesn't refer to parts and accessories. And we would also say that quite apart from that, human dolls is more narrow a range than other toys, animal toys or monsters. That could be non-human toys, which could be a very broad spectrum. But we don't really need to dwell on those points because the fact is parts and accessories is specifically mentioned. So that's GIR 6 and GIR 3A. And the fact is that Build-A-Bear's construction gives effect to the language. There is a reason why parts and accessories has been specifically mentioned. We've seen that in relation to skates. It's done for a reason. There's no basis to cross that out or ignore it. The words are clear, and indeed there is nothing to say that parts and accessories doesn't mean parts and accessories.
Sorry, the reason being, by analogy with that other bit of the CN that you showed us, that there is a nil rate. So that's why you need to, the rating is different from dolls. Is that the particular reason why they're picked out and put separately?
So
that you took us to the skates bit.
Yeah.
We talked about the different liabilities that applied. And one thing that does appear when you look at the dolls subheading here is one reason for putting parts and accessories separately from even from dolls is that they, for reasons I'd be really interested to know why parts and accessories that go with human dolls carry no customs duty liability. But they do. They have a different liability, different classification.
Now, they didn't need to put parts and accessories in the nil dash heading to do what they've done at the 2 dash heading, because they could have just left it dolls representing only human beings, and then below that, dolls, parts and accessories. That is in fact what they did with skates. If my ladyship looks at skates again, the 1 dash heading does not mention parts and accessories, and yet they've broken it down further below into ice skates, roller skates, parts and accessories. So it's not the language is not the language in the 1 dash heading is not explained by what happens below, and indeed because they didn't need to put parts.
Didn't need to, but I mean, at a just a more questioning level, could that be why they expressly why the 1 dash heading doesn't just say dolls representing only human beings, it also talks about parts and accessories thereof, because they're in fact going to split those into 2 different liability categories.
They didn't do that. They didn't do that with skates. No. They didn't do that with skates.
Could the purpose be to bring in dual-use items?
To bring in
dual-use items.
Indeed, my lord. That is in my submission the reason.
But when I say that, items in respect of which there is no principal use.
So by the time we've got the accessories that have filtered through into this 1 dash realm are already, note 3 has been applied to the 950300, the nil dash heading as a whole.
Yes.
And this is saying, right, if they're parts and accessories of human dolls, they go here. Doesn't matter if...
I see, yes. So just suppose you've got an item which is principally used for dolls and stuffed toys. So it goes into the top heading. If you didn't refer to parts and accessories, where would it go at the next level if it were used equally for dolls and stuffed toys?
Indeed.
But I think I'm making a point that would be against you. So you have an item where at the subheading level there is no principal use. At the top heading level, they are principally used for both dolls and stuffed toys. If you didn't refer to parts and accessories in relation to dolls, you wouldn't know what to do with the the mixed use item, would you?
No.
But that might be said to be against you, because when you find something that is principally used with stuffed toys, you stick it in with stuffed toys. The reason for including parts and accessories would be to deal with the case where there is no principal use, as between dolls and stuffed toys.
But it also it deals with the case where one has to follow the language. To have got there, it's got to have a principal use with
The composite.
toys. Yes, the totality, and then following the language, parts and accessories, not qualified by that language we saw in that other chapter, section 16, which said parts and accessories means solely and exclusive. It doesn't have that. So what this is saying is, if it's a part and accessory, applying the language of a human doll, then it falls within that.
And I follow that's your case.
Yes.
But in terms of why there might be a reference to parts and accessories, that might just be to deal with the item where it is used equally for dolls and stuffed toys, because otherwise it wouldn't fit into either category, even though it was in the top heading.
Yes, that's right. But the language that's been used, it doesn't say that. It says parts and accessories. So in other words, if it's a part and accessory, that's where it goes. My submission, there isn't really scope to read in some limitation to that.
Well, the alternative view is you don't need to read in a limitation. You just apply note 3, where you have an item that has a principal use. Note 3 tells you where to put it. The parts and accessories with dolls only bites where you have an item that doesn't have a principal use.
But note 3, well, I made my submissions on that, but in essence, there would be a conflict between the words parts and accessories that have been deliberately chosen as the ordinary meaning of the words, and note 3 in that concept.
I mean, that's the GIR 6 point.
Yes.
Suppose that doesn't work for one reason or another. You then say, well, GIR 3A, but GIR 3A only itself works if a chapter note doesn't exclude it. And if note 3
Yes.
is overriding, GIR 3A is excluded.
Yes, but note 3, all note 3 does is say put it into toys representing animals or non-human creatures. It doesn't say don't put it elsewhere. It still leaves...
Doesn't note 3 say two things? One is you look for the principal use, and secondly you classify according to principal use. So it's not just what does this accessory attach to principally. That's where it should go, as I read note 3.
Yes, but it doesn't rub out. Indeed, it goes there, but it doesn't rub out the words in other subheadings. So it doesn't say despite any more specific wording elsewhere. It doesn't say that.
No.
So
Yeah.
now there's a case on the importance of language, the combined nomenclature, decision of an opinion of the Advocate General, which am I doing for time? I've got half an hour. I will try and finish by lunchtime. So the case emphasises, the opinion of the Advocate General emphasises the limitations of reading words in. It's at the Authorities Bundle 13, First Authorities Bundle, tab 13, 118. And so if I could invite the court please to read paragraphs 84 Schultz. Paragraphs 84 to 88. And simply, the point is that one is bound to follow the words. And we've seen how carefully...
If they're unambiguous.
If they're unambiguous, which parts and accessories my submission is. It's not qualified by that chapter section note that we saw in relation to section 16. It means what it says. And one has to follow the words. The customs officer has to follow the words. Something which is fairly and squarely an accessory for a human doll should be classified where the wording says parts and accessories of human dolls. That's the simple and logical approach. And it's also it gives the right answer, or a logical answer, because the distinction between dolls and the dolls heading and the animal toys heading is very, very slight. A single non-human feature can cause the item to become an animal toy. And that is deliberate. So it's very easy to be taken outside the doll's heading. And what that means is you're going to have many accessories which fit both. You'll have trousers with no slit, which fit a quasi-human figurine with wings on its back, or claws, or robotic eyes. You've got hearts that fit both. What this wording, Build-A-Bear's construction does, or interpretation does, and what the wording does, is to ensure that if it's part and accessory, fairly and squarely part and accessory of a human doll, that's where it's classified, even though it could be used with a non-human doll. Now the slit, which is discrete, makes no difference, shouldn't alter, there's no logical reason why that should alter that analysis. I've already described the facts. It was found that the slit was discrete. I won't repeat that. When we come to shoes, the facts are slightly different. The First-tier Tribunal, finding of the First-tier Tribunal in relation to shoes is at page 208 of the core bundle. Paragraph 202. So if I could invite the court to read 1 to 4.
Sorry, 203.
203, I beg your pardon. So, on the basis that parts and accessories, all that matters is whether it's a part and accessory of a human doll, we have the finding, paragraph 202, sub 3, that the footwear is suitable for use with certain dolls, such as Build-A-Bear's Honey and Daisy and Cabbage Patch dolls, which have more rounded feet than those corresponding to a human foot. And that is sufficient to conclude that these were accessories of human dolls.
Honey, Daisy and Cabbage Patch, they're all humanoid, are they?
They're all humanoid. So I can, very briefly, if I take you to the supplementary bundle, you can see the
No,
picture.
I'm happy to take it from you. I thought they were, and I think that if you want
They are. They have. I'll give you the page references in the supplementary bundle. It's just helpful to maybe have a look at those. Pages 118, 100, 134, and 142. You'll see that the bears and the dolls, they have round feet, and the shoes fit both. Now, it's because the First-tier Tribunal considered that Note 3 applied that it nevertheless considered that these should be classified in the animal toys subheading. If, as I submit, they're wrong, and the question is, are these parts and accessories, and that's the question, then subparagraph 3 is the relevant finding. These are used with human dolls, they're accessories of human dolls. But even, and this is the additional point which Lord Justice Newey required us to explain, request permission to make this point, even if that's wrong, even if your Lord and Ladyships are against me on the points I'm making on GIR 6 and GIR 3A, nevertheless, and even if it is Note 3, nevertheless, there was an error of law in the First-tier Tribunal decision. So, so the logic of the First-tier Tribunal decision is that it fits some dolls, but it fits more bears because bears have more rounded feet than humans. That was the logic. And that's how it was understood by the Upper Tribunal. That's indeed how the First-tier decision was understood by the Upper Tribunal. Find 255. Page 255, paragraph 1374. The Upper Tribunal considered that in the circumstances, the FTT was entitled to conclude that given the round shoes would only fit on dolls' feet where those feet did not represent human feet, the defining feature of the doll subheading, they could not be principally for use with dolls. In my submission, one is comparing relevant items from the dolls heading and relevant items from the animal toys heading. And if those relevant items, if those are items with round feet on which shoes can fit, there is no basis, as with hearts, to distinguish between shoes used with human dolls and shoes used with bears or animal toys with round feet. There's no basis for that. One has to actually look at the relevant parts of each of the heading. And that was an error of law. There's an error of logic there to say because it fits some dolls only and more bears, then it is an animal toy. There's no principle for that. And it ignores the obvious point that shoes are not for animals at all in any event. They're for humans. So in my submission, there was an error in the logic of the First-tier Tribunal in that respect. And the Upper Tribunal should have recognised that, and the point that one needs to compare like with like. So even if Note 3 applies, Note 3 was misapplied in this case. These shoes, they fit human dolls and they fit animal toys in the same way that hearts do, and therefore the analysis should follow that, which is Note 3 is disapplied. This was the Upper Tribunal's logic, and therefore the parts and accessories wording should prevail. So those are my submissions. I have managed to keep it all lunchtime, unless your Lord and Lordships have any questions for me.
No, thank you very much, Mr. Sykes. Mr. Thomas.
My lord, my ladies, there are two tasks for me, either of which would entail the appeal being dismissed. First, to support the decision of the Upper Tribunal on the effect of Chapter Note 3. The second, by reference to our respondent's notice, support the view of the First-tier Tribunal in respect of Chapter Note 3 and or GIR 3A. The starting point and any real consideration of the issues in the appeal has to begin with assessing the meaning of Chapter Note 3 in the legal context that's before you. In other words, the meaning of the chapter note viewed against the interpretive rules which designate the importance to be given to that note. Before we delve into the legal material in the GIRs, the background is that the dispute is concerned with goods which have been found to be principally suitable for use with stuffed bears. In the nomenclature, stuffed bears are other toys, so these are goods principally suitable for use with other toys. That is where they have been classified by the first tier and by the upper tier. Their classification is therefore aligned with their principal use. Their principal use being an objective characteristic of the goods as found by the first tier. That result is fully in accordance with the cardinal principle of classification law, which is that classification is determined by the objective characteristics of the goods. In addition to all that, we have in this case a specific chapter note which says, subject to note 1 above, parts and accessories which are suitable for use solely or principally with articles of this chapter are to be classified with those articles. So the result of the first tier and the upper tier is also fully aligned with that concluding section of chapter note 3, are to be classified with those articles. The appellant says that is legally wrong, and they must instead be classified with dolls as accessories of dolls, despite the fact that they are not principally suitable for use with those dolls. And the basis for that submission is that they are capable of being used with dolls, and a series of factual findings made by the first tier saying that they can be used with dolls is relied upon as being the footing for that submission. Now, I say that Chapter Note 3 is clear on its face and produces the result, is directive in the way that each tribunal has identified it to be, and that there is nothing in the legal materials that you've been shown, including GIR 6, which causes it to be disapplied at all. And I therefore take head on and reject the submission that there is a conflict between, on the one hand, the operation of Note 3 to classify these goods with bears, and on the other, the presence in the subheading for dolls of the words parts and accessories thereof. It's critical to my learned friend's case that he identifies not only the presence of those words, but a frank conflict between that and the result or the operation of Note 3, such that Note 3 can be said to be incompatible with those words in 9503. And that, I suggest in summary, is an impossible task, because on the Upper Tribunal's analysis, parts and accessories thereof in the dolls heading applies to a number of classes of goods. It applies to classes of goods which are solely or principally for use with dolls. It applies to goods which are equally suitable for use with dolls, toys, or other articles of heading 9503. And it may even apply to other goods on the basis of the Upper Tribunal's finding that there was some independent route into 9503, the subheading, other than by reference to Note 3. So there is a plain meaning to be given to and a scope of application for those words.
Sorry, can you just spell out what you mean in that last part? So I follow your point about solely or principally and items equally suited.
Yes.
And then you say it may even apply in relation to...
Yes, that is because the Upper Tribunal, I mean, we disagree with this point in our respondent's notice, but assuming that they're right about this, the Upper Tribunal say at 108, page 249, if you see their third line down, but even without Note 3, in our view, clothing items and wigs would fall within heading 9503. The HACNs in two separate places refer to parts and accessories. So what they're saying there is that there could be material in the explanatory notes which contain lots of detail about what is and isn't included, which could found in an appropriate case, not this one, but in an appropriate case, a conclusion that something fell within the dolls accessories heading anyway.
Just, I'm not sure this matters, but are you ending up with a third category though? I mean, can we postulate something that is for use with dolls, either principally or in relation to other items within 9503?
Yes.
I mean, is there something else that could be of use with dolls, but of use with something outside 9503?
I suppose a series of things with minority uses where nothing was predominant. It wasn't equally suitable for two things. It might be minority suitable for 14 things or 3 things or whatever. But nonetheless identifiable as something which was an accessory because it could be used with a principal item.
Yes.
So it could be a third category. It doesn't need to be a third category, but I referred to it for completeness because that seems to me to be the breadth of what the Upper Tribunal decided about the construction of Note 3.
Mr. Thomas, can I take... Sorry.
Sorry, go on.
I was going to just... I wondered if paragraph 125 was the one that dealt with this potential third category, and it was a paragraph I
Absolutely.
slightly struggled over, but the...
Yes.
It's a gap that it's a notional gap where the Upper Tribunal says there's a gap between Note 3 and parts and accessories in the single dash subheading.
Yeah.
But there may be things that fall in there, but we can't quite think what they are at the moment.
Absolutely.
Yes.
Is that right?
Yes. Yeah. That's the other paragraph I would have had in my mind. So that being the case, full effect, in other words, is given to the parts and accessories wording. It's not a completely otiose reference with little or no scope. So it can't be suggested that Note 3 is in some way muscling in on territory naturally and obviously covered by that phrase. Indeed, the opposite is the case. Note 3 in this case is being applied to direct classification on the specific ground that the test it promulgates has been met, namely that the sole or principal use is with the articles with which it's classified. So Note 3 isn't being used in a way which is outside the plain meaning of it, and it's not being given an effect which isn't plain from its terms. So let me just identify the importance of this is that the chapter notes and the terms of the headings are applied at Rule 1 stage, and the principal basis upon which classification is accomplished is by Rule 1. And only when Rule 1, including all the matters that you take into account at Rule 1, require you to proceed to the other rules, do you then proceed to the other rules. And that's important. Could I just invite you to look at Epsom Telford, please, tab 32 of the authorities bundle, for a summary. And it's page 442. Can I just invite you to read 8 and 9? Actually, you don't need to read 9, it's not in point. 8 and then paragraph 10. So the emphasis there that Lord Justice Chadwick gives is to the explanatory notes to the rules, which say the rule can only take effect, this means Rule 3, can only take effect provided the terms of the headings or section or chapter notes do not otherwise require. You've seen the rules of interpretation, but you haven't seen those explanatory notes, and I should show you them. They're at bundle 3, page 837. Bundle 3, page 837, tab 46. Now, to be clear, these are the harmonised system explanatory notes. So these are the worldwide explanatory notes, but explaining the significance of the general rules for interpretation, which are identical as between the world system and the community system, as they're required to be. The particular part that I draw your attention to is 3B. So this numbering is confusing because it's not about Rule 3B, this is Explanatory Note 3B. Where appropriate, provided the headings or notes do not otherwise require according to the relevant provisions. And there's an explanation of that in 5A. It says, in provision 3B, the expression provided such headings or notes do not otherwise require is intended to make it quite clear that the terms of the headings and any relative section or chapter notes are paramount. They are the first consideration in determining classification. So that, my submission, is important because it serves to give a flavour as to the role that chapter notes play in securing the result without needing to go on to subsequent considerations. That overall theme, in terms of giving the Rule 1 materials their evident purpose in achieving classification, is why we cited the now quite old case of VTech, which I will just also take you to, if I may, tab 30 of Bundle 2. VTech Electronics. And it's page 421. This was a case about toys and games, and essentially the objects were toy computers. They looked like toy laptops, but you could play games on them. And so VTech said, well, okay, they're toy computers, but they're games. The games are on the computer. So this is both a toy and a game. There were two separate headings for toys and games, so separate things. So you have to go to Rule 3. There was a regulation which said, no, it's Rule 1, they're just toys. And the tribunal said, no, they're just toys, it's Rule 1. And that overall approach of not going to Rule 3, even though they had features of games in them, was upheld by Mr. Justice Lawrence Collins, as he then was. Could I just invite you to read 105 and 107 and mark 106? So the submission I get from that is that the chapter notes and section notes where relevant, but here chapter notes, are to be given their acknowledged purpose in achieving classification and not used as a means of generating a list, which then has to be subject to a separate process under Rule 3 and following. They are notes which are there to help achieve classification at the earliest stage, that is to say, to reach a definitive result at the earliest stage. And that manner of treating those legally binding materials fully supports the approach of the Upper Tribunal in treating Chapter Note 3 as dispositive of the issue. So those submissions we summarise in our skeleton at core bundle 103. Paragraphs, could I just invite you to read paragraphs 23 to 25? And after the adjournment, I will seek to support that submission by reference to the permission decision of Lord Justice Newey and some of the case law which has dealt with similar sole law principle tests and how it's been treated. So I'll do
So
that.
this is a convenient moment.
This is a convenient moment.
In which case we'll come back at 2 o'clock.
Right.